Welcome to EUPrivacyForAll Session40 on GDPR, Article 2, Material Scope. There is no change to be noticed in the numbering of Article 2 regarding material scope. This article stresses the fact that the regulation will apply to the processing of personal data when they are wholly or partly processed by automated means, but also when not processed by automated means, whenever they form part of a filing system or are intended to form part of such a filing system. The GDPR excludes the application in the frame of activities falling outside the scope of the Union law, whenever member states carry out activities falling in the scope of common foreign and security policy of the Union, whenever a natural person processes data in the course of a purely personal or household activity, and finally, when competent authorities do process data for the purposes of prevention, investigation, detection or prosecution of criminal offences. For the processing of personal data by Union institutions, bodies, offices and agencies, the Regulation 45/2001 still applies, and it is the same regarding liability rules of intermediary service providers regarding the application of Directive 2031 on e-commerce. In Recital 15, 16 and 18, some exclusions are highlighted. For instance, in Recital 15, it is made clear that files or sets of files, as well as their cover pages, which are not structured according to specific criteria, will not fall within the scope of the GDPR. Recital 16 highlights that the regulation does not address issues of national security or common foreign and security policy of the Union. Moreover, the GDPR will not apply to processing of personal data by a natural person in the course of a purely personal or household activity. So, for instance, it could include networking activity, such as social networking and online activity. However, Recital 18 underlines the fact that the regulation applies to controllers or processors providing the means for processing personal data for such personal or household activities. Recital 20 identifies another exclusion. The competence of the supervisory authorities should not cover the processing of personal data when courts are acting in their judicial capacity. So the activities of courts would be excluded. And Recital 21 remembers the fact that this regulation is without prejudice to the application of the e-commerce directive regarding, for instance, the liability rules of intermediary service providers. The Directive 95/46 in Article 3 on the scope made clear that it applied to the processing of personal data wholly or partly by automatic means, and to the processing otherwise than by automatic means of personal data which form part of a filing system or intended to form part of a filing system. This is the same approach as in GDPR. The directive shall not apply to activities which fall outside the scope of community law and activity by a natural person falling into the scope of a purely personal or household activity. What should accountable data controllers and processors get prepared for? They will have to know that they fall within the scope of this regulation when they process data wholly or partly by automated means, and when the processing operations other than by automated means form part of a filing system or are intended to do form part of such a filing system. The regulation will not apply to activities falling outside EU law, EU security and justice policy processing, purely personal or household activities held by a natural person, such as social networking and online activity, prevention, investigations, detection or prosecution of criminal offences, and files or sets of files which are not structured according to specific criteria. Controllers and processors will have to bear in mind that the liability rules of intermediary service providers set in the Directive on e-commerce will still apply. Finally, the regulation will set a protection of individuals that will be technologically neutral. It does not depend on techniques used. A caveat to bear in mind: controllers or processors which provide the means for processing personal data for personal or household activities will fall into the scope of the GDPR. So the questions triggered now are: how will technologically neutrality apply? And how will the GDPR apply to the providers of the means used in personal activities?